What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid on its face.
To be addressed, that would be addressed at the preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir,
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all.
All right, buckle up, folks, because today we're diving into the magical world of sovereign citizens, and our protagonist, Daniel McGoo, is ready to compete for the crown of dumbest sovereign citizen on earth, narrowly challenging Eric Martin for the title. Court's about to call him to the stand, and what follows is a parade of legal gymnastics, rights, claims, and procedural missteps that would make a law professor weep. Daniel thinks he can outsmart Michigan statutes and the judge simply by citing obscure codes and trying to define lawful detention in his favor. But here's the reality: judges don't play by your internet interpretations or buzzword bingo. They rely on timing, procedure, and clear responsibility. Watching someone try to bend reality in front of a judge who's already seen it all is like watching a slow-motion car crash.
And make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Okay, Ms. Lobby has let me know that all paper discovery has been sent to Mr. McGoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McGoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. McGoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a
All right.
speedy
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I expect that you would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and
should
then
have them as well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you.
Right off the bat, Daniel tries to argue that a charge is invalid because he wasn't technically in jail, he was in a hospital. Classic sovereign citizen move. Pick apart technical definitions and pretend that literal semantics can erase actual charges. The judge isn't impressed. This is a asterisk textbook of why courts don't care about your creative interpretations of the law. You could argue all day about whether a hospital is a confinement facility, but unless the statute specifically requires physical incarceration, you're wasting everyone's time. And notice the emotional play here. Daniel is framing himself as the clever victim of a technical loophole. It's dramatic, but it won't get him anywhere. The lesson? Courts prioritize facts, precedent.
You are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, including and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a 3rd offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. that I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel?
Now Daniel pivots to a Howarth Amendment argument, questioning how the arrest happened, whether his license was revoked, and if he was even notified. It's ambitious, but scattered. He throws multiple violations at the court at once, hoping something sticks. Judges see this all the time. They call it spaghetti pleading, throwing a bunch of theories out at once and hoping one hits. Problem: you can't demand dismissal on vague, unproven claims. Courts require evidence, witnesses, and a structured argument. Daniel's tactic here is pure performance art, impressive in creativity but weak legally. This is a great teaching moment. Procedural knowledge beats passion. Without documentation, timelines, or witnesses, even the most dramatic constitutional claim falls.
I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And
a response from the people regarding his bond.
The people would ask the bond to continue, and he also at the bench for failed to appear before Judge Simpson. So
yes,
that warrant would also hold up with respect to the other. I'll wait. There are pleadings filed by the defender's office. Our office will respond to that. And I guess my one remaining point would be, should with the court's appointment Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the defender's office.
yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
and a lot of these are
Dave,
facially
46.
invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff,
I was not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out. And that if that's true, these cases, I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh, yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it put on its face.
Here's where things get interesting. The court discusses discovery, specifically video evidence and USBs being sent to Daniel in jail. Now, instead of digging in, Daniel tries to argue he's ready to cross-examine officers immediately. This is a classic mistake. You don't get to argue evidence before you've even received it. Courts aren't about improvisation, they're about preparation and fairness. The judge and prosecutor are clearly giving him the chance to review all evidence first, but Daniel is